You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then, on April 7th, it alleges that you had your hands in your pants, moving in and back and forth. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report.
Right here, things quietly get serious. A guilty plea plus a pre-sentence investigation means the judge already has a full snapshot of this man's past. And once that report is in, the courtroom stops being theoretical. This is where outcomes get real.
Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. I've been looking at the PSI report. Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears, with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis.
This is the legal landmine. Felon plus firearm equals 0 tolerance under Texas law. Intent doesn't matter the way people think it does. Possession alone can collapse an entire defense in seconds.
Was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track. He understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further.
This is the classic redemption pitch. Family support, employment plans, second chances. Judges hear this every day, but the real question isn't hope, it's history, and history is about to walk into the room.
I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun, that's like
But the law, that's not what the law is. Okay? So you don't get to just.
And here's the moment everything cracks. You cannot plead guilty while claiming innocence. The judge isn't being dramatic. This is constitutional law. If you didn't do it, the case goes to a jury, period.
Take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily, or are you pleading guilty because you did what they charged you with?
And I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on that, y'all.
Sure.
That case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, to another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Noticed that you were watching the person doing rounds, had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I don't know, sleep on my back.
Sir, we're really gonna do that?
You asked me and I'm telling you, I sleep on my back. I have sisters. I have a mama. I don't do that. Them people write whatever.
They're
Octavia
making
Sanders
this up
walks
on
back
you.
into
That's
Judge
terrible
West's
of them to do
courtroom,
that.
already standing on borrowed time. Her name echoes through the room, tied to theft cases, broken probation,
You
and
were
promises
off
she once
parole
made and quickly
the way
forgot.
I do the math.
At first,
less
the
than a
hearing
year.
feels procedural,
So you did
almost
your whole 8
routine,
years?
until the state introduces body camera footage.
What'd you do
The
in
video
prison to have to
becomes
do your
the turning
whole 8
point.
years?
It shows detention, merchandise on the floor,
For doing what?
and quiet admissions that contradict
Just
every
tattoo
excuse.
them,
In that moment,
contraband.
the courtroom
Not following the
stops
rules
being
while
about
you're in
paperwork
prison.
and becomes about truth.
I'm going to find that you
As
previously
arguments
entered your plea of
unfold,
guilt.
At this
Sanders
point,
tries to
probation
explain
is off the
herself.
table.
She talks
Jail
about her
conduct
children,
matters more
her
than
mother's
letters,
dementia,
promises,
and how
or
hard
explanations.
separation feels.
The court isn't
But
just
Judge
sentencing
West
to
cuts
crime,
through the
it's
emotion with
sentencing
sharp clarity.
behavior.
She
Freely and
refuses to carry
voluntarily.
the weight of
Find
choices
sufficient evidence
Sanders
to find
already
you
made.
guilty, and at this
The
time
judge
find you
reminds her she
guilty
was
of unlawful
warned,
possession of a
given
firearm by
leniency,
felon,
and
sentence you
trusted
to a
not
term
to
of 6
repeat the
years
same
in the
crime.
institutional
That
division of
trust,
the Texas
once
Department
broken,
of
cannot be
Corrections.
begged back.
You will receive credit on that
Responsibility
sentence for any
becomes
time that
the
you've been in
central
custody
conflict.
that the law gives you
When
the right
Sanders
to
shifts
receive.
blame to the people around
I'm
her,
handing you the trial court
judge delivers the
certification that
line
shows
that
this
seals
was an
her fate.
agreement that I
Being
followed, and
present
so you
makes her
waived your right
accountable.
to appeal, and
Being
you're lucky that
silent
this
before
was
the
the
video makes
agreement.
her dishonest.
Mr. Smith was
Probation
generous.
was not a pause
The fact
button.
is, this
It
you
was a
could have been
test she
enhanced
failed.
to a second
The
degree
sentence
felony
is
because of
firm.
your history,
15
and you're
months
lucky you
in
weren't.
state jail. No
I have also
theatrics,
handed
no
you a written
hesitation,
admonishment regarding
only
your ineligibility to
consequence.
possess
The
a
courtroom
firearm
barely has
or
time to
ammunition.
breathe before another
Obviously, you
case
know this,
begins,
but I'm required to read
reminding
this to you.
everyone how
Because
fast
of the
justice
judgment
moves.
entered against you, you're
Later,
ineligible under
Sanders
Texas law
returns
to
to plead
possess a
guilty on
firearm
a new
or
theft
ammunition.
charge. This
Possession of a
time, there is
firearm
no
or ammunition
argument.
could lead to
The
charges
deal
against
runs
you.
concurrently,
Firearm is a
softening
legal
time,
term,
but
and you
not
should
the
read the
lesson.
written admonishment
Judge
I
West
provide you
warns
to
her
see what
plainly.
devices qualify
Today
as
could
a
have been
firearm.
worse.
If you
Next
have
time will
questions
be.
about the laws
The
that make you
courtroom
ineligible to
empties,
possess a
but the
firearm
message
or
lingers.
ammunition, or about how
Mercy
long
was
it lasts,
offered.
you can talk to Ms.
Warnings
Holmes.
were clear.
You can go with the bailiff.
And when chances are wasted, justice does not repeat itself. The silence after sentencing says everything about consequence.
This is not just a case. This is a fight for justice, where one question from the judge can change a life forever. The silence of the victim, the arguments of the lawyers, and the verdict that decides the truth. Welcome to Court and Courtroom, where every case reveals a new truth, and every truth leaves a lasting impact.